Hey, good morning. My name is Michael Feigen. I'm a patent attorney. I practice primarily patent and trademark prosecution, which is the obtainment of patents and the obtainment of trademarks as opposed to litigation. Do a little bit in that, but my primary area of practice is actually obtaining patents and trademarks as well as copyrights. And I encourage everyone to first start out by opening the PowerPoint slides, the presentation, because I will be referring to it heavily. In the very beginning of the presentation, you can find my contact information. Phone number 212-316-0381. Website is patentlawny.com. Again, it's patentlawny.com and also patentlawNJ.com. While we're at it, patentlawpa.com. I have locations in New York City, Passaic, New Jersey, and Philadelphia. And this is what I do for a living. So, and you can look at my website, patentlawny.com. You can see some of my sample patents. Some of them I'm actually going to be referencing today and talking about this. So, going on to the next slide, the outline of today's presentation. First, we're going to have a little introduction, a little what to look at in office action, and see some crazy office actions. And then we're going to go to step 2, which is drafting a patent with the office action in mind. It might seem in today's topics responding to an office action, but the process really starts in how you draft the application. Then third, we're going to talk about non-prior art rejections, which are 101 rejections. And I'm assuming to the people I'm talking to, when I say a 101 rejection or a 102 rejection, you know what I'm talking about. This isn't an intro to patent law class. This is actually, once you're already doing it, this is actually the meat and potatoes when you're actually practicing. And then number 4 is prior art rejections, 102, 103 rejections. Those are rejections over previous patents, patent applications, anything. The examiner interview, when you talk to the examiner at the patent office. And finally, once we've done all that, you're ready to write your response to the office action. And you put it in writing. So moving on, so we're at the introduction section. And the next slide, quick background to the process. So just to give you a little roadmap of what we're talking about here today. In the patent process, if you look at that slide, first you receive your disclosure from the inventor, you generally conduct a novelty search. After the novelty search, then you draft your patent application, you file at the patent office, you wait, depending on how you file it, less than 1 year if you're using the pilot program to get them to respond quicker, or sometimes I've had one office action come in 4 months after filing without such a thing. In other cases, you wait up to 5 years. So once you get that office action, that's what we're going to talk about. The office action is the substantive examination by an examiner at the patent office, and your now preparation and response to it. So a little circle there on the process there, the arguments and amendments. That's where we are right now. That's what we're going to talk about today. So, as many of you probably know, I'm talking to mostly lawyers in the audience here. There's a lot of treatises, and there's a lot of courses and so forth on things like claim drafting, on procedural things, on memorizing the MPEP, as we all had to do to pass the patent bar exam and so forth. But I think there's a lot of room for how to get to responding to an office action. And I also, before we go into the next slide, I also preface by saying this is, it's a little bit of an art how you respond to an office action. Some of it is exacting, some of it is you have to respond, you know, basically there's formalities, there's the way that you structure your office action, but some of it is also an art. How do you put your arguments together and so forth? So I make no claims to saying that this is what I'm going to teach is the only right way to respond to an office action, but I'm giving a lot of my methods, what I've developed over years of doing this, and how I do this. And having said that, I had one person comment to me, he's been doing this for 37 years, but he can always learn something. You can always learn something new. So I'm going to hopefully give you my take on how to respond to an office action, some of which I've developed, a lot of which I've learned from the people who taught me, which I'm very grateful to, and they might be watching. And in any case, thank you. And in any case, we're going to go on with that, and also to say this is, of course, not necessarily legal advice. Please don't think this is legal advice. This is presentation for teaching. So on the next slide, response to crazy office action. This is a real case here. And this is a real how you respond to such a thing. And again, there's no one right answer, but here's what I did. So the claim in the application was, claim 7 was a device of claim 1, I'm just giving you the part that we need to talk about, wherein said device is coupled to a neutral wire. Okay, so that's a claim in your patent application. The device is coupled to a neutral wire. Office action says, see Heart 5B. That's it. He doesn't explain, what do you mean Heart 5B? So Heart 5B, presumably he means figure 5B of the Heart reference. He did actually say what patent the Heart reference was. So we look at figure 5B in Heart. So go on to the next slide. And again, that's under the heading response to a crazy office action. Now, figure 5B is this XY graph with time in the x-axis, amplitude in the y-axis, and a current signal. Does anybody out there watching this live or afterwards on the recorded video, does anyone out there see a neutral wire in that figure? If you do, okay, you're on the examiner's side, but personally I don't. So I have a telephone interview, and I try and talk to the examiner. He refuses to discuss this claim. Every time I point to this, and he refuses to discuss the dependent claims in general, he wants to talk about the independent claim. Because I was willing to say, okay, there's some things in the independent claim, and his supervisor is on the phone too. So there's examiners, there's supervisors, you can go up the chain of command as well. There's different ways. I'm not really talking about that so much today in terms of appeals and petitions and so forth. I'm just talking about the response to the office action itself. Stay tuned, I might give a class on pre-appeals and appeals and so forth, but for now, talk about the office action. So after 20 minutes of this back and forth, the examiner finally says, look, here's why I didn't give you a proper response to that. He says, we're so pressed for time. Right now, I mean, this goes back and forth, but right now, as the time I'm giving this video presentation, the examiners are under tremendous pressure to reduce the backlog. One examiner told me that they're trying to get the backlog down to 6 months from 5 years in some art units, that they're trying to get down to 6 months, they're going to get you the first office action. That's their goal right now. And they have each of their cases listed on their computer docket, and it goes, I think, from green to orange, means they're about to have run out of time to respond, to red, and if they don't get that response out, they're in trouble. And they're given a ridiculous amount of work that they have to do in a short amount of time. So it's common refrain, they say, look, we just don't have enough time to do it. So what that means for us as practitioners is, unfortunately, right now the pendulum has swung in a way that sometimes we're getting not so good office actions. On the other hand, I've also gotten a lot of allowances, because that's the other way they can dispose of a case, is to allow it and let it issue. But either way, whatever the case is when you're listening to this presentation, whether you're given more or less time, you got to spell it out clearly. You got to make your arguments short, concise, spell them out, and you got to hopefully reach the examiner and talk to them, converse with them, get on the good side, you know, let them know that you know, it's not personal, there's nothing against them. You stick to your legal arguments, and you just make the best arguments you can, and you go through the process the best you can. And it's probably good advice for life as well. So, all right, we're on to the next section. Drafting your patent with the office action in mind. So what I'm going to talk about in this section is there's certain things that you can do when drafting your patent application to anticipate common rejections. So going on to the next slide, drafting your patent application with the office action in mind. Remember that time thing I spoke about? Some examiners will only read the claims. They're not really going to read much more than the claim. Sometimes they do, sometimes they don't. There's some very good examiners that'll read your whole application and point out a grammatical error you had on page 16. Does happen. But the claims are the key to the patent application. So you make sure that every one of your key terms in the claim is defined. You want to avoid a 112 rejection. I've had rejections where I've said, for example, this could be X, Y, or Z, and the examiner will reject it and say, that's not a definition, that could also include Q, which I rejected it over. So now I make sure to write it more clearly, spell it out. This limitation is defined as, define it. There's a definition you can refer back to. You might want to give other examples, other definitions and things if you have to amend your claims later. So that's, you know, another thing to make sure of. And other examples are, if you say substantially, define the word substantially. This one, a couple years ago, people use substantially all over patent applications, all of a sudden rejections started coming all over the place. 112 rejection. I don't know what substantially is. You didn't define substantially. So, I mean, sometimes my definition is as simple as substantially parallel as understood by one of ordinary skill in the art. You know, we're using the Focida test. And that seems to be valid. I've never gotten a rejection when I've substantially used that definition. Usually I give other definitions just in case, because you never know. You can't add new matter, you can't add things later. So I haven't tried that one by itself. I think it would work, but again, I would still recommend, you know, if you can put in better definitions, put in more exacting definitions, hey, that's all the better. So again, I just spoke about this. Have backup terminology and variations in case you need to amend later. You know, you might have your amendments in mind in some cases. Use signals so you can find the variations. For example, you might use the term alternative embodiment. It's best not to use preferred embodiment or and language such as that, because there's a court case that says, oh, you preferred this, that means you don't prefer this, and we're not giving you the infringement benefits because on your alternative embodiment because you said you didn't prefer it. So now we make all embodiments equal. And again, defined as X and Y. It's something I like to do, is just plain old use the word defined. So there's no question what you mean, and when you get a rejection that says because you use the word parallel and they cite something else that's technically parallel, then you say, no, here's my definition of parallel. Parallel is not the best example because that is a mathematical definition. You know, something more amorphous. Once you give the definition and they cite something else that matches in keyword but not in definition, you can just point to that in your office action and say, here's the definition, examiner. They usually say, here's in response to the office action, here's the definition. Don't make it personal. Then it's very easy then to overcome these things. Otherwise they say, well, I can read your claim as broadly as will allow, and it could read on my definition too. It's a way of avoiding that. It's a good step to take. All right, so moving on to the actual parts of the patent application. The background, as many of you know or should know, it's an optional section. I'm not going to talk about when you shouldn't put it in. You know, there's different schools of thought on that, but what I will say is you can use the background section to your advantage. You can discuss the prior art. You can sell your invention to the patent office. In the prior art, it accomplishes perpetual motion. You have perpetual motion, but the perpetual motion isn't through the space-time continuum. So that's a problem, and nobody's been able to figure that out, and that would really make it much better, because then Marty wouldn't have had to go to 88 miles an hour. He could have gone to 22 and made it without the whole thing, but then we wouldn't have Back to the Future 2 and 3, and it would be, you know, I don't know, that would be a whole mess. But in any case, you can sell it to the examiner. You can tell the examiner what you're talking about, where to search. You know, you can talk about this is the closest background, but of course, be careful, because anything you write here is omitted prior art and may be used against you. You know, just like they say as regular lawyers who practice that normal kind of law, you know, keep your mouth shut because it can and will be used against you. So, you know, you want to be careful what you say. Use it to your advantage, but be careful. Don't admit what your invention is. Don't make it obvious what the solution is when your invention, what you're claiming, is the solution. Okay, summary, again, is actually an optional section. Track the claim language. Write it in plain English. Instead of using comprising as we do in claims, use regular English. Write it as close as possible, and it might be what a judge or a jury is reading to determine infringement, because when they read your claims, they don't understand all the seds and comprising and so forth. So they'll read it there to understand what your invention is. Drawings are great. It makes your life easier when responding. It just makes it easier to read your application, because you can look back, read the drawings, there's your method flowcharts, there's the pictures of it. Drawings are obviously required if you have device claims. Method claims, they're not necessarily in all applications. As soon as I finish drawing, just to answer this question. It's good practice to copy a relevant portion of the drawing in the response. So I actually put in my responses to the office action, be like, as I'm going to go into later in the examples, examiner, you cited Hart, figure 5B, here's figure 5B. I put it right in the office action. Here's what I claim, here's a picture. In that case, we put a picture of a neutral wire. But in any case, that's, it helps a lot. I mean, sometimes I'll take, here's my drawing, here's a drawing of the prior art, here's what we claim, here's why what I claim is analogous to my drawing. Over there, you can't possibly say it's the same thing, it doesn't show it. Burden of proof is always on the patent office. I shouldn't say always. Burden of proof is to show it. If it's not clearly shown there, it shouldn't count. not going to say you won't get a rejection, but it shouldn't count if it's not clearly shown.